Imagine being in a situation where you're forced to confess to something you didn't do, and that confession is made to the police. Now, can that confession be used against you in court? Many believe that once a person confesses to the police, they are automatically guilty. But is that really the case in Indian law? Today, we are going to break down the complexities of confessions before the police and whether they are admissible in court. In India, confessions before police officers are a tricky area of law. Under the Indian Evidence Act, not all confessions are treated equally. Section 25 of this Act plays a significant role in determining whether a confession made to a police officer can be used as evidence against a person in court. The law recognizes that confessions made under pressure or coercion, especially to police officers, could be unreliable. After all, the fear of police interrogation could make anyone say things they don't mean. So, is a confession made before the police admissible in court? Let's explore the answer. Before diving deeper, here are some key takeaways you should keep in mind. First, Section 25 of the Indian Evidence Act. A confession made to a police officer is inadmissible. 2. Section 27 Exception. Certain parts of the confession may be admissible but under strict conditions. 3. Voluntary confessions. Confessions made voluntarily outside police custody can be considered. 4. Judicial confessions. Confession before a magistrate carries more weight. Let's unpack each of these points in detail. According to Section 25 of the Indian Evidence Act, any confession made to a police officer is completely inadmissible in court. The law was put in place to avoid the use of force or coercion during interrogations. This rule was reinforced to protect the innocent and ensure no one is forced to say something against their will. For example, in the case of Pakala Narayana Swamy versus Emperor, the Privy Council clarified that confessions made to the police can't be treated completely, as there is a risk of coercion. Now, there is a slight exception. Under Section 27 of the Indian Evidence Act, if the confession leads to the new discovery of evidence, that part of the confession can be admitted. But this is a very narrow exception and comes with strict scrutiny. For instance, if a person confesses to stealing a car and leads the police to the stolen vehicle, that discovery can be admitted in court, but not the entire confession. In the famous case of Pulikuri Kotaya versus Emperor, the court held that only the information that leads to the discovery of new facts can be considered admissible. A voluntary confession is valid if made outside police custody and not under duress. If someone willingly confesses to a crime without any pressure or influence, and this happens outside police supervision, it can be considered as evidence in court. Confessions made in front of a magistrate, known as judicial confessions, hold significant importance. These are admissible because they are made before a neutral and unbiased authority. The Supreme Court has time and again upheld this principle, emphasizing that confessions made before the police are inherently unreliable, but those made before a magistrate carry greater credibility. If you or someone you know has been forced to confess before the police, here are the steps you can take. First, consult a lawyer immediately. If you are made to confess under pressure, the first step is to contact a lawyer. They will advise you on how to retract or challenge the confession in court. 2. File a complaint. If there is any form of physical or mental coercion, you can file a complaint against the police officers involved. The complaint can be lodged with the senior officers, human rights commissions, or even in court. 3. Document evidence of coercion. If you were coerced into a confession, try to gather evidence such as medical reports or witness statements. They can prove you were under duress during the police interrogation. Recently, with the introduction of the Bharatiya Sakshya Adhiniyam 2023, there has been a push to modernize and reform the criminal justice system. The new law attempts to address gaps in the Indian Evidence Act, focusing more on safeguarding individual rights. As per a recent ruling by the Supreme Court in 2023, any confessions included in a charge sheet without adhering to the proper legal provisions can be struck down as inadmissible. Additionally, this act focuses on increasing the responsibility of the police to ensure transparency during interrogations, including recording sessions where confessions are made. This will provide more protection to accused individuals and create an additional layer of accountability. Let's recap the key points. First, confessions made to the police are generally inadmissible under Section 25. 2. Section 27 allows for certain exceptions when new evidence is discovered from a confession. 3. Voluntary and judicial confessions hold more credibility in court. 4. If your rights are violated, consult a lawyer and document evidence of coercion. If you found this information helpful, make sure to hit the like button and share these videos with others who might benefit. Subscribe to our channel for more insightful videos on Indian law. Let us know in the comments if you have any questions and we'll be happy to answer them in our next video. Take care and bye.